This is America and the Courts, C-SPAN's weekly look at the federal judiciary. In this edition, Supreme Court Justice Stephen Breyer at the Hemisphere Summit on Justice and Freedom of the Press in the Americas. Justice Breyer discussed judicial independence at the three-day conference held in Washington, D.C. in June. Journalists and Supreme Court justices from 20 nations attended the summit, which was hosted by the Inter-American Press Association. The organizers of the event make remarks prior to Justice Breyer.
Bueno, continuamos entonces, disculpándonos por la interrupción. Decía que era esta una necesidad impostergable.
This is a very important need, and this is something that we're going to agree on, that the relations between the press and the courts has been something that we have not really wanted or the desired level, and this is the reason why we're here together to discuss this, the role of the media and the relation with the courts. We are gathered here together, and this is what we have in common, this desire to work together. Even we're together because we also face criticism by the public, and also we are subject to criticism. We are also united in the search of fair and just solutions, although they're on the basis of different situations. The press, under the public opinion, and at the same time, the judges serving the public. We're also united in our common vocation, seeking that our citizens will be able to have a better life in our society. Although on the basis of different attitudes, the press many times has been subject to the criticism of society, and at the same time judges, even though it has a public service to perform, it also must be independent. Even though there are internationally observed attitudes, we work on the basis of different doctrines, whereas most of the countries in the hemisphere, the judges have been operating on the basis of very definite, concrete judgments. Press continues to follow very subjective code of ethics. Furthermore, there are cases, although these are the exceptions, that there are legal standards where the press is not legally bound to comply with. For instance, there are some standards that are unconstitutional in certain governments, which really go towards restricting freedom of press. And this, unfortunately, in Latin America, this is something that is taking place. Also, on the other hand, we have other standards that can be sometimes suspicious and undemocratically and limit public access to public information. I remember in my country, Peru, for instance, there was a case of a negotiation for the purchase of police cars, but that was covered up because of military secrecy law. So it is within this very complex framework that the IAPA has tried to have a better relation with the court, a relation which I am pleased to say it will be the start of a new debate and forum that is going to be taking place in different countries in order to analyze and explore the relation between judges and the press. This round will be the second of that IAPA is going to be held later on, or the committee of Chapultepec had for 3 consecutive years a debate and symposium in order to warn the governments about the existence of those laws and standards in those countries which really put in danger the exercise or the free exercise of the profession. So we would really have to consider all the legislation in effect in all the three Americas so we can come to a conclusion what would be the principles that we finally came to adopt as the declaration of the Chapultepec. This is a declaration that was finally delivered to all the governments. I believe that we all agree that this effort geared towards opening up a dialogue between judges and journalists is very vital. Never before we came together around the table in such a massive and organized manner to examine common problems, to allow journalists to understand the workings of judges and to allow judges to understand the logic of journalism. Among other positive results, this dialogue will clear up misunderstandings on either one of the parts. And we must take as a basis the recognition that at some time the media must be bound by certain code of ethics, just like the judges. Many times, also, they haven't been following exactly their code of ethics, but I am certain that we also agree that those excesses must not be the norm, and they cannot be used as an argument to label our institutions. Because honorable judges, whenever they are, daily give a testimony of performing justice that would honor the system, just as there are very serious and responsible journalists that act in favor and uphold the norms of ethics of their profession. However, it is valid in both fields to remember a phrase here that it was expressed by more than 50 years ago by a founder of the IAPA, who said, journalism, according to the way it is exercised, it could be one of the most noble of professions or the worst of work or of activities. So inspired in this one of the professions, we have structured this meeting. During the different sessions, we're going to be exploring the different options that we have in order to improve dialogue between judges and journalists. We're also going to be exploring the topic of judicial independence, as well as the different legal framework for the freedom of press in our countries. I'm talking about the Declaration of Chapultepec and the Inter-American Declaration of Principles of Freedom of Press, sponsored by the OAS, Organization of American States. Also, we're going to be talking about insult laws and libel and the proper forum where this should be discussed. Also, we're going to be talking about the principle of real malice coming from the Anglo-Saxon system and of its complete application. During our last day, we're going to have a mock hearing. It is sort of an experience or experiment that will make it possible for us to see face-to-face the legal problems that both judges and journalists face. But of course, and obviously, we're going to have limitations, time limitations. So for now, I would like to ask the panelists to limit their interventions to only 8 minutes, and the speakers to 15 minutes. And I would like to really respect the time limit, otherwise we're not going to be able to complete our program, and we would like not to be rushing at the end of our program. In order to discuss all these different topics, we have had very distinguished representatives coming here to Washington, including 52 Chief Justices of Supreme Courts, including lawyers, journalists, and activists in the area of human rights, around 250 people altogether. And once again, to all of you, thank you very much for being here with us. Our thanks to the McCormick Foundation also, which makes possible the Chapultepec problem and therefore the holding of this conference. I would finally like to thank the cooperation of the Inter-American Human Rights Commission of the OAS, the Law School of the American University of Washington, the Legal Initiatives Council of Latin America, and the Legal Council of Lawyers of the United States, and to the Media Center and Court Center of the Legal School of the United States. I would like to conclude by making an appeal that whoever is participating in this summit to really open up our hearts and minds. That's the only way to be able to understand one another. And for this, we will be able to achieve everything that we all want, a more just and a better society for all of us. Thank you very much. I leave the president of IAPA, Mr. Robert Cox.
It's an enormous honor for me to be with you here today, and I'd like to thank the Honorable Justices for being here and to express our enormous pleasure in that we have someone with us today who I think epitomizes what some people might call an American dream, but I think I would call an American reality. Justice Bryer was born in San Francisco in 1938 to a lawyer and the daughter of an immigrant Polish cobbler. This is an American story, and we will see today the personification of the great realizations in this country. I tend myself to think of Supreme Court justices as rational oracles, and I think that we will see something of that. After attending a magnet high school, Breyer studied at Stanford, where he graduated in 1959 with great distinction. He then attended Oxford University as a Marshall Scholar, graduating with first-class honors in 1961. In 1964, he graduated magna cum laude from Harvard Law School and was the Law Review articles editor. In 1967, Justice Breyer, then just Stephen G. Breyer, married Joanna Hare, a clinical psychologist who works with cancer-stricken children. They have 3 children, Chloe, Nell, and Michael. In his spare time, the justice enjoys hiking, jogging, cooking, reading, and I believe soccer. Justice Breyer clerked with Supreme Court Justice Goldberg in 1964 and 1965. 2 years later, he began teaching at Harvard Law, where his courses included administrative law, antitrust, and economic regulation. He also taught in Australia and Rome. Since then, he's written several books and articles on administrative law and economic regulation. He served the government in many, many capacities. He was an antitrust assistant for the Department of Justice in 1965-1967, assistant special prosecutor on the Watergate Special Prosecution Force in 1973, and as both special and chief counsel to the U.S. Senate Judiciary Committee. In 1980, President Carter nominated him to the U.S. Court of Appeals for the First Circuit, where he served as Chief Judge from 1990 until 1994. In 1993, he became Associate Justice of the Supreme Court. And one of the things that I noticed in my reading about Justice Breyer was something that I found incredibly fascinating. I think many of you have probably noticed how quotations are taken totally out of context and the actual meaning of them completely changed. One of them that I remember seeing once outside a bookstore that said that all men are equal, but some men are more equal than others, and then it said Orwell afterwards. Of course, the quotation is that all animals are equal and some are more equal than other, and it wasn't Orwell that said it, but he used it in Animal Farm to explain the totalitarian concept. Very interesting exchange between a colleague of Justice Breyer took place, and it concerned the poetry of Robert Frost. I think many of you will have known, and I myself for many years thought that the idea that good fences make good neighbors was the point that Robert Frost was trying to make. That point was used by another justice, used by Justice Scalia, and obviously, in this case, the great justice who is with us today had read Robert Frost with more attention and more understanding than Justice Scalia, and it must have been a great moment, I think, in every way. And he pointed out that the poem actually says just the opposite. It says that, and before I built a wall, I'd ask to know what I was walling in or walling out. In this case, we certainly do not want to wall out. And perhaps for many years, journalists and judges, certainly in Latin America, in my experience, my 20 years in Argentina, had very little to do with each other. And this was a lamentable affair. And we, as a journalist, we certainly know the importance of the independence of justice, which is the Justice Breyer will address us today. I'd like to call upon him and thank him very much for this great honor.
Thank you. That was a very nice introduction, Mr. Cox, and that is a good theme. That is a good theme. For this meeting, the poet says, there's something about me that does not like a wall. That's good. En todo caso, voy a decir unas palabras en español para darles una bienvenida calurosa de mí y de mis colegas a todos los presidentes de las cortes, los ministros,
all the presidents of Supreme Courts here, the ministers, judges, journalists,
todos los colegas
and all the
distinguidas
colleagues
que
most
están
distinguished
aquí
that are
esta
present
mañana.
here today.
Pero no se preocupen.
Don't worry,
No voy a hablar
I
mucho
will
en
not
español.
continue in Spanish.
No hablo bien español.
My Spanish is not very good.
Y Tony Garcia me dijo
Tony Garcia told
muchos
me
años que hay
some years
mucha
ago
gente
that there's a lot
que
of
piensan
people
que tampoco hablo bien
that
inglés.
think that I don't even speak good English.
Pero otra cosa,
One more thing I
lo
wanted to
siento
tell you
mucho
is I'm
que
sorry
estamos yo
that
y los miembros de mi
myself
corte
and the
en
other
un
Supreme judges
periodo muy
are
ocupado.
going through a very,
Eso,
very busy
por la razón que
time,
las invitaciones
and
por
that
las
is
reuniones
why
sociales
the
no llegaron
invitations
hasta
for
ayer
the
en
social
la tarde.
events did
No es
not arrive here
posible
until
que
yesterday.
nos veremos
So
mucho en
we won't be able
días.
to share a lot of time
Pero,
with you.
estamos
Nevertheless,
con
I want you
ustedes,
to know that
no
we will be
en
here,
cuerpo,
not
pero
in
en
body, but in
espíritu, por
spirit.
cierto. And I'm now going to speak in
So-
English. And what we're going to talk about is judicial independence and the press. And my role primarily is to talk about the first part, the judicial independence. But we'll end up with the press. Now, I'd like to make 4 points. The first is why is it so important to have judicial independence? The second is how, in the United States, do we try to achieve it? The third is the most important difficulties that stand in the way. And the fourth is who are our natural allies? Those are the 4 questions, points, discussion points that I want to raise. Right. Point 1. Why? Why judicial independence? Well, we all know the basic reasons. They're simple, and they don't really have to do with the personality of the judge. They have to do with the people who live in the country where the judge works. And the importance of judicial independence must be for those people. And today we would say among the people of all our countries, they want 1, prosperity, and 2, freedom. And as to prosperity, I cannot say this better than Alan Greenspan has said it, that you cannot really have prosperity without investment. You cannot easily have investment unless there is financial security for those who invest and those who work in the enterprises that are built with their investments. And part of that security means legal security, and part of it requires honest, efficient courts to look at contracts, to resolve disputes among the people who work in these places. The second, we also know perfectly well, that although judges cannot guarantee freedom, they can help. And to have honest, independent courts means that when there are encroachments by others upon basic human liberty, there are people who will say no. They do not always succeed at saying no, but without independence, they cannot have an opportunity even to try. Now, we know those reasons, so I needn't go further into point one. I can bring up point two, is how in the United States have we tried to guarantee that judicial independence? And here we have a number of institutions. We have in our Constitution guarantees that judges will serve in office for life. That's quite a long time. Thomas Jefferson used to complain about our Supreme Court. He said the members of the Supreme Court of the United States never retire and they never die. We also are guaranteed in the Constitution a salary that shall not be reduced. They didn't think of inflation at the time they wrote those words, perhaps. But that offers something of a guarantee, medium kind of guarantee. And we know that we want, though we have nothing in the Constitution that says it, a certain share of resources so that we can do our work effectively. Now, those kinds of things are necessary for judicial independence in every country, not just the United States. You must be certain, when you decide your cases, that you will not be impeached as a result of those who are in political authority not liking the result that you reached. And unless you have that assurance, you cannot decide the case honestly. Now, that's something it took people in the United States quite a long time to learn. In the early history of this republic, one of our presidents, indeed a great spokesman for liberty, Thomas Jefferson, thought it might be a very good idea to remove judges who were opposed to his particular political point of view. But he failed in that effort, and the fact that he failed has been marvelous for the independence of the judiciary in the United States for the next 200 years. Now, we have other institutions. We have, for example, an independent disciplinary authority within the judicial branch. Though they cannot remove people from office, only Congress could do that through impeachment. We have our own system of administration, where we administer our own resources. And we have systems that I think are equally important, designed to give the public confidence that we are honest and doing our job properly. The most annoying of those is the requirement that I must and my fellow judges must every year disclose on a piece of paper to the press every penny that I earn, every penny that my wife earns, every penny that my minor children may have earned over the year, every gift, every asset, every liability. And if you think that isn't annoying, because the press immediately goes and writes articles about exactly how much money we have, you're wrong. It's very annoying, but it is absolutely necessary. It is necessary so that the public has the impression, because they know that the press is not an easy pushover. They are tough and will try to get the information, and therefore, if that information is available and they write about it, they have some assurance of honesty. They can look to see whether or not the judges are doing their jobs quickly, and the answer is quite often no, but they're able to find that out. They are able to see how effective we are, and that is hard where resources are not always adequate, and that is difficult when the public cannot often, vast numbers of people do not have enough money to come into the courtroom far too often. I'm saying, in saying this, that our system is far from perfect, but we try to have certain institutional guarantees that the judges are honest, that we try to do our jobs properly, that the courtrooms are reasonably open, and that the average person will have an opportunity to get his case resolved. Are we perfect in solving those problems? Absolutely not. Are they necessary to try to resolve in order to obtain the judicial independence that we want? Absolutely. All right. I open that subject simply for discussion. 3, what is the single most difficult obstacle to judicial independence? I would say this most difficult obstacle is one that can be worked on only over a period of decades or perhaps centuries. And that is the obstacle as to whether or not the public will accept the institution. Now, what do I mean by that? I can best illustrate what I mean by giving you 3 case examples drawn from our own history. Let me go back to the year 1832, 1834. I'll tell you about a famous case. It's called Worcester versus Georgia. That case arose 175 years ago when the Cherokee Indian tribe, which owned land in northern Georgia, land that was guaranteed by treaties with the United States, became worried because gold was discovered on the land. When they found gold on the land, their neighbors, the Georgians, decided that they, the Georgians, would like the gold. And they invaded the Indian territory in order to throw the Indians out and to take the land and the gold for themselves. Now, the Indian tribe at that time was a very civilized tribe. They had an alphabet, they had schools, they were farmers, they had a constitution. And they said, what we ought to do is hire a lawyer. They hired a lawyer, the greatest lawyer of his day, Willard Wirt, who had been Attorney General. He brought a lawsuit in, eventually, the United States Supreme Court. The United States Supreme Court, unanimously, I believe, said that this land does not belong to the Georgians. The land belongs to the Indians. It is guaranteed to them by a treaty. The federal government has promised that they can have this land forever, and the Georgians must leave. What happened? The President of the United States, Andrew Jackson, supposedly said of the Supreme Court's decision, John Marshall, he is the President, he was the Chief Justice, John Marshall has made his decision, now let him enforce it. And President Jackson sent troops to Georgia, not to help the Indians, but to evict them. The federal troops forced the Indians out of Georgia. They traveled what is known as the Trail of Tears to Oklahoma, where their descendants live to this day. Keep that in mind. That's case 1. Now let's go into the future. After a civil war and many other events, go to the 1960s. In a second case called Cooper versus Aaron, the Supreme Court of the United States had to consider whether they were going to enforce the 1954 decision called Brown versus Board of Education. Brown versus Board, as you probably all know, was the decision that said segregation on the basis of race is contrary to the Constitution of the United States. But Cooper versus Aaron arose because a governor of Arkansas said, the Supreme Court is not going to tell me what to do, and he stood in the schoolhouse door with the state troopers to prevent the black children from entering the white school. In Cooper versus Aaron, the Supreme Court of the United States, unanimously, each member signing a piece of paper saying, you must let those children in the school. But it wasn't the Supreme Court that sent the troops. President Eisenhower sent paratroopers to enforce the court's orders. Perhaps he'd learned from Andrew Jackson a century and a half before, because this time the troops went not to defy the Supreme Court, but to enforce its ruling. And with the help of the paratroopers, those black children went in the door of that white school. Now, that desegregation of the South did take and require the judges, but the judges could not have done it on their own. If there were 900, or 9,000, it required a country that was willing to send those paratroopers to help those children go into that school. Now let's go forward a few more years. Let's go to last year, when our court decided a case called Bush versus Gore, which in effect had an effect upon an election, in all likelihood, where the country was divided. Think of that case. Or think cases that I wrote and others wrote only a few months before, involving abortion, involving prayer in the schools, involving issues where our country is extraordinarily divided. And if you think people do not feel strongly, you haven't heard some of them talk. They do. Well, what I find remarkable about those cases is the fact that hardly anyone thinks the following is remarkable. Despite the division, despite the strong feeling, no one doubts that the country will follow the decision. That's remarkable. And the fact that no one thinks it is reflects 200 years, not a document not words on a piece of paper, but 200 years of practice, including a civil war and 80 years of racial segregation, rather shameful, in 1/3 of this country. My point is, you cannot solve this problem in a conference. You cannot improve the situation with a meeting. That's helpful. But what we want to achieve, is the kind of behavior, of habit, of understanding, of realizing among people who are not judges, not journalists, not lawyers, but ordinary citizens of the country, that their freedom and their prosperity in part depends upon following judicial decisions made by an independent judiciary, even when those decisions, in their view, are totally wrong. And believe me, we are not oracles. We are easily capable of many mistakes. And we hope, each one of the 9 of us, when we're there, that our mistakes will not be too terrible. So, that, I say, is the obstacle. And it is a big one, and it is an important one to overcome, and all we can do is work on it. Now, who are our allies? We have 2, and they're not always, as judges, allies that we embrace with all of our hearts. Perhaps we should, but sometimes we find them annoying, as they find us. 1, an independent bar. Why an independent bar? Because when we try to explain that we need more resources, that we need better working conditions, that we need more pay, people listen politely, or perhaps not politely, and they go about their daily business, because what they're really thinking is, everyone has problems, and quite honestly, judges, many of them have fewer problems than most. If what we think is important really is important, we cannot be the ones that will convince people. It must be the bar that says, but they need this not for them, but for you. It must be the bar that explains to the children in the high schools or explains to the adults in the community why it is important to have an independent judiciary. Why, from their point of view, that means from the point of view of their prosperity and their liberty. One is not a good advocate in one's own cause. One needs the bar to help do the explaining, and when the bar finds something wrong, they are the ones that go to the legislature and say, do something about this so we can maintain the judicial institution. And we need the press. Why do we need the press? We need the press because it is the press that sometimes saying things we don't like at all will convince the public what the need for an independent judiciary is, will convince the public that, in fact, this is an honest institution, that will convince the public that, in fact, they need the resources for you, and this is why. Will they always be accurate in what they say? Absolutely not. Is it necessary that they have the freedom to make the statements and convey to the public that they are free to say what they want? Absolutely. How else can you have the institution that is necessary to the public without the press to explain it? And how else can the press be credible otherwise than to be free? So when I think about it, though this is a little bit maudlin, but I believe it in my heart, it seems to me that the press and the judiciary are two different institutions that have similar goals. They are, in a sense, twins, fighting like mad, but nonetheless necessary to each other. Necessary for what? Well, I'll tell you the story that made an impression on me. I read only last week in a speech by Gerhard Casper, who is the president of Stanford University, now retired, who is German and who grew up just in the period after the Nazis, just after World War II. And he said when he was growing up, his teacher, who had been almost put to death, rescued by the Allies the day before her execution, had never spoken very much about the Nazi period. And something came up, and the class said, "Why do you not tell us about this period? Why do you not tell us what happened these last few years?" And she said, "It isn't because I approved of it. I was a resistor. I was almost put to death. I didn't approve. But this is what happened to me, and I didn't know. I've always felt guilty. I felt terrible about this. But I'll tell you what it was. I was walking in the late 1930s through the street, and I saw a truck, and there were policemen loading into the truck Jews. And I went up to the policeman, and I said, 'What are you doing?' And he said, 'Where are they going?' And he turned to me and he said, 'If you want to find out, get on the truck.'" You see why? That isn't how we find out things. We find out through the press. You have the press, maybe that doesn't happen. You have an independent judiciary, maybe there's less chance. That's why we're twins. That's why underneath it all, we're there. We're there just to be a little extra safeguard to see that maybe there is a little bit less of a chance that something like that will happen. That's why I'm glad you're here. That's why I'm glad we're working on a project that may take us 100 years, but it is a very worthwhile project. Thank you for coming, and thank you for inviting me.
Thank you. The only comment, a brilliant mind, no doubt about that. Justice Breyer has agreed to take a few questions, so I'd be delighted if anybody would have any questions for him.
Horacio Aguirre.
I'm Horacio Aguirre. I am director of Diario Las Americas from Miami. It's fine. Yeah. I'm repeating, Horacio Aguirre. Horacio Aguirre. Can you hear me?
No,
yes.
Entiende.
Yes.
I can understand.
Yes.
Yes.
Can you hear the judge? Can you hear me, Judge? Can you hear me? Yes. I'm Horacio Aguirre, director of Diario Las Americas from Miami. I would like to congratulate you for your Spanish and for the wonderful speech. I have a question. Yeah. Yes. Yes. I would like to congratulate you for your Spanish and also for the magnificent speech. I have a question that has to do with the First Amendment of the U.S. Constitution that has all the support of the free press and of the free citizenship in the United States and all over the world. Nevertheless, I would like to ask the following, and this might show how ignorant I am on this point. There is the perception that it's very difficult to know how many things are going to be included within the concept of the First Amendment. This First Amendment comprises 5 lines on freedom of expression, freedom of religion, and the right to face the authorities and to ask them for their needs. But anytime covered by the First Amendment, we have a decision by the Supreme Court that is being interpreted as being covered by the First Amendment, like a nude person just going to the street and dancing and saying, I'm expressing myself, so I'm covered by the First Amendment. I would like you to tell me, are there any limits? Because there are people that tell me, we don't know how far this can go. This goes much beyond what is indispensable for freedom of expression. So nobody knows if there are any limits, and that is my question. I don't know if you understood me.
That's a very good question. Very good. It's the same in every constitution. You have the expression, la libertad de expresión. ¿Qué quiere decir eso? It's general. There are some things that are at the heart of the matter. Suppose, as happened in this country in the First World War, a newspaper opposed to the draft puts a cartoon that shows some big, undesirable people labeled political opponents crushing a poor innocent woman called the draft, you say. And suppose the newspaper editor is put in jail for running that cartoon. That is the heart of expression. And to put that person in prison because of the political cartoon is contrary to freedom of expression. It took the Supreme Court of the United States decades before it came to the point where it could make clear that the freedom of speech and of the press protected the entire country from that kind of clear violation. Since then, there have been many extensions. And when you depart from the heartland and get towards the outer limits, of course, you find cases on which people can disagree. Does nude dancing violate freedom of expression? I believe I joined an opinion that said no, it does not. It's not expression. I think so, but I can't remember too well these days, so I'm not sure which side I was on. But I guarantee it was controversial. And there will be other matters that I think are well beyond any possible interpretation. Suppose that a bank robber takes $1,000 out of a bank and he at the point of a gun, and he says, I am doing this to express my hostility to organized society. I do not think any judge would interpret the word freedom of expression to help that bank robber. Now, if you say there are many middle cases, that is the explanation of why it is so difficult at this time of year to get all 9 colleagues at this meeting where they would prefer to be. But we are working on cases which raise difficult issues along the border. Suppose a judge runs for office. In some states, judges are elected. To what extent does freedom of expression mean that the judge can talk about pending cases? Difficult question. We'll have, or we have had, campaign finance cases. We have had pornography cases. We have had dozens of cases that are difficult and on the border. So if you want a clear answer from me as to what does or does not violate the First Amendment, you will not get the answer because I am not being difficult. It is because I find the questions difficult. That's where we are. Okay. No? Any? Si no hacen más preguntas, voy a hablar en español. Yes. Yeah, right.
Gonzalez, Communication Director of the Judiciary in Chile and law professor of communication. More than a question, I would like to make a comment in relation to what you said. In that, and by following a Spanish professor and following his experience, I've been teaching the judges something very similar of what you said, that the judiciary power and the press are very similar and very much alike. As I said, it's not an original thought. I've also said that they are colleagues, and in what respect? In the sense that if we go to the classic theory, the journalist, whenever he reports to the public, he is presenting that really belongs to the public. He's delivering that to the public, and therefore he is doing justice or an act of justice in performing that sort of service. Likewise, the judge is performing an act of justice when he's performing that public service. That is, he is setting a balance among the parts. That's something that should prevail. So whenever I tell judges that journalists are also people who exercise justice, many times they begin to appreciate the work done by journalists, because then they understand that it's based on the same criteria they're using, which is given to the public what it really belongs to them. I don't know whether somehow this point of view has been taken to consider this relationship between the press and the judges in the U.S. Thank you.
Thank you. Thank you. I think that's a good statement. All right, so yes.
I would like to ask you a question in relation to privacy from 2 points of view. First of all, privacy in normal relations, where somehow it affects the privacy of a person when it comes to press publications, and whether that's going to have a greater or lesser public dissemination. And then in another case, a more critical situation of privacy, for instance, the lack of public access to public information in cases of war, for instance. What is your opinion in those 2 cases?
Privacy, I think, is going to be the most difficult issue to face us, because the right of privacy is very important to individuals as a matter of human dignity, and at the same time, it is often at war with freedom of expression. How, for example, will we deal with the fact that with cell phones today, it's possible to pick up conversations that are meant to be private all over the world? It's possible to have cameras for security purposes that monitor what's going on in every public place. It's possible to record every single stroke, finger stroke, that a person makes on a computer. And with computers, it's possible to record the results of all 3 of those things, index them, and play them back later. That is a major technological change that dramatically affects the possibility for interfering with the privacy that people expect in their ordinary lives. And if there is total freedom to do those things, there won't be privacy left. And I don't see how you can have a dignified human life without it. At the same time, not surprisingly, journalists, being enterprising, are perfectly happy to use some of those methods if they'll get a more interesting article. And you cannot expect them not to try. So where does that leave the court at the moment? It's left us with some very interesting cases where we have not made firm rules. I thought we had 2 years ago a fairly easy case and an extremely difficult one. What I thought was the fairly easy case was that the police had a machine that they could train on the outside of the house, and it would register the heat that was generated within the house. And by monitoring the heat that was coming out of the house, they could tell if someone was growing marijuana in certain rooms. And the question was, is that an unreasonable search to do that without a warrant from a magistrate authorizing the search? Our court held that is unreasonable. And given the earlier law on the subject, I thought it flowed pretty naturally. And it isn't enormously burdensome to require the policeman to go to the magistrate to get the warrant if he has reason to think they're growing the marijuana. And If he doesn't have reason, why should he do it? All right. But the hard case was this. The hard case was a statute says that you cannot eavesdrop without a warrant, without permission, except under certain circumstances, on private conversations. There was a private conversation talking about something very newsworthy. Another private person, let's say a neighbor, eavesdropped with a machine, and he picks up the conversation. He goes to the newspaper and throws it over the transom. We're told. Who knows? But that's what they say. That's what we take as a fact. The newspaper, in fact, it wasn't a newspaper, I'm simplifying, it was a radio station, but nonetheless. Imagine they read it and they print it. Now, has the newspaper violated the law? Can the newspaper be proceeded against in a civil case for damages by the person whose privacy was infringed? Now, why do I say that's hard? Well, the newspaper got it in an innocent way. On the other hand, it did violate the privacy that the statute protected. And how did we come out? We said, well, in this case, the newspaper wins, but if it had acted less innocently, who knows? And if you want to know what the law is and you read our opinions on the subject, I'm afraid I have to confess it will be hard for you to get a clear idea. And that's because we had different views, and we wrote different opinions, and we were hesitant, some of us, to decide too much, too quickly. Why? Because we're developing technologically. Things are changing. Let's see what happens. So there's another reason why I don't give you a straight answer, or can't. All right. Yes? Yes,
Good morning. My name is Eugenio Herrera from the Reform newspaper in Mexico. I would like to ask what would be your recommendation or opinion in relation to the following. We have a positive situation in many of the Latin American, a certain trend to the opening of public opinion. What do you feel about this, and what would you recommend to the countries that have a written system and that is closed, and that therefore there is very little scrutiny by the citizenry? That would be my concrete question.
Well, when you have most of what you do in writing, the fact that most of what you do is in writing doesn't mean it is secret. France has a system that is mostly in writing. Most of the Latin American systems are modeled after the Napoleonic system. They have far more reliance upon written procedures than we do. But a judge, including one who works in writing, can, in fact, be quite transparent, because the written materials submitted to the judge come in and can be made available to the public. The written opinion that goes out from the judge can be made available to the public. And once you scrutinize what goes in and what comes out, you really scrutinize most of what happens. I mean, no one can scrutinize in our court what goes on in my head. Sometimes not even I know. And so it's possible, I think, to reconcile a written system of procedure with an open system that is reasonably transparent. Was that basically what he was driving at?
Excuse me, we're going to have to go to our panel now.
Thank you very much. I'm behind schedule. I'd like to thank the Justice very, very much. A really remarkable presentation, superbly done. Thank you very, very much.
For further information about the judicial branch, go to cspan.org. Join us on America and the Courts, Saturday evenings at 7 Eastern, 4 p.m. for viewers on the West Coast. This is America and the Courts, C-SPAN's weekly look at the federal judiciary. This week, more of the Hemisphere Summit on Justice and Freedom of the Press in the Americas. Last week, we presented Supreme Court Justice Stephen Breyer's address on judicial independence. This week, the panel discussion on judges and the media that followed the speech. The conference was held in Washington, D.C. in June. Journalists and Supreme Court justices from 20 nations attended the summit, which was hosted by the Inter-American Press Association.
A remarkable panel, all right, and we're trying to move as quickly as we can to more questions. We're honored to have the Chief Justice of the Supreme Court of Mexico, Justice Góngora. Justice, would you come up for me?
Agradezco a la Sociedad Interamericana de Prensa y a la Escuela de Derecho de la American University esta invitación. Mejor no podría haberse encuadrado el tema de esta sesión, el papel de los medios frente al órgano judicial y la independencia judicial. En un momento de transiciones vitales, como parte de esta preocupante crisis de la pérdida de los referentes y liderazgos, en fin, de lo que algunos llaman la supeditación de lo público a lo privado. Inicio el tema con esta preocupación en virtud de que uno de los principales rasgos de esta crisis política que viven las democracias modernas es el debilitamiento de la credibilidad social, no solo hacia las instituciones del Estado, sino hacia las mismas organizaciones de representación política tradicional. Y en estos rubros estamos incluidos los órganos judiciales y los propios medios de comunicación. ¿Cómo podemos hacer frente a este proceso que por vertiginoso pareciera inevitable? Esta es la pregunta de fondo que debemos hacernos los jueces y periodistas. Los invito a plantearnos algunas reflexiones al respecto. Supongamos que un juez dicta una sentencia con visos de insuficiencia en su fundamentación, digamos poco rigurosa, y que durante el proceso solo examinara algunas pruebas y no todas las que le fueron presentadas. Si a ello añadiéramos una conducta de soberbia por parte de nuestro hipotético juez frente a las críticas contra su fallo, ¿cuál creen ustedes que sería el resultado? Ahora bien, imaginemos a un reportero que presenta a través de su periódico un reportaje de alto impacto social, que a primera lectura tiene visos de poco rigor periodístico. that it's not very well written. In other words, it seems that this journalist has not gone through all the sources, that he didn't have enough time, and that he somehow used documents that were not actualized. Let's say that he decided not to print all the declarations and all the witnesses, and he decided to print only what he thought was the best. What do you think the result would be? I think in both cases, what is being put in danger his credibility and social trust. And these are two very important factors, because both sides, judges and reporters, depend on the trust of the people. What the consequences would be? I would like for us to ask ourselves what kind of impact this kind of conduct will have for the social credibility of the judicial power. Probably people will decide not to go again to the normal and judicial channels, and they would start having their own private agreements. They would start using their own justice, and this will just destruct. They will be very destructive for a nation. In the other case, the conduct of the reporter, if he continues doing this, will put also the credibility of his own paper and all the media in question. I think that both the media and the judicial power share some very important responsibilities, and although we are not linked directly, our credibility links us. Our viability, in my opinion, that depends on the ethics and the responsibility, the independence and transparency that we work with before the people is very, very important. The judicial federal power of Mexico is aware of this, and that's why has started a relationship with the journalists that's respectful and ethical. We understand the high social responsibility that the media in Mexico has before the citizens, and we know that they can fulfill their obligations only within a framework of freedom. And some people think that we are in cahoots, actually, but that is not the case. We are governors and public servants, and we are subject to public scrutiny. And this was decided by the citizens. We, as the judicial power, express our concerns for some parallel judgments that are happening. When the media starts giving their opinion, we also value very much the social function of the journalists in a democratic society, and also what they do to control some excesses. We cannot ask the media to become the checks and balances for the judiciary powers and then jail them or accuse them. It is always better to have a free press that may commit some excesses, because in the end the citizens will judge this as they judge us. This is always better to have
a press that is not free, because in our case, the democracy has grown only because of the work that the media has done, the media that understands its historic responsibility. This is not a new criteria. The Supreme Court of Justice in Mexico have always defended freedom of expression since 1835. It's very important to point out that although this guarantee of freedom of expression was proclaimed from the first constitutions in Mexico, it suffered a lot during dictatorial regimes, but it has been covered again by the Constitution of 1917. And I think that this is one of the best and greatest successes that the Mexican people has had. In February of 1922, the Supreme Court defended journalists, saying that among the human rights, we have the right to judge the conduct of public servants as long as their private life is not being touched.
En 1931 estableció, aunque la libertad de prensa en algunos casos puede seguir caminos extraviados, no debe ser reprimida, porque la lucha contra su acción, por grave, dañosa y perjudicial que se le suponga, no quedará justificada si se lleva a cabo matando la fuente de energía que trae consigo, porque mayores males resultarán con el ahogamiento de las ideas, perenne origen de todos los abusos del poder. En otras jurisprudencias, la Corte mexicana ha apoyado
Mexican court has supported this freedom of the press.
El Dios Cronos me avisa que me queda un
Cronos says that I have 1 minute left.
En base en ese aviso del Olimpo,
I would like to finish this and
en el Poder Judicial Federal
And I would like to say that in the federal justice system, we cannot say that a good relation with the press is a synonym of no criticism. We are a state judicial power. We serve the citizenry. And so I'm totally convinced that the criticism of a serious press, although sometimes it's uncomfortable, has to be accepted as part of public scrutiny. Society expects the judges to act ethically and professionally, but I also think that the people expect the same of the journalists. One of the greatest investigative reporters said, I think that to be a good journalist, you have to be a good man or a good woman first. You have to be a good human being first. Those that are bad cannot be journalists. And I think that this can be applied to us, the judges. Thank you very much.
Thank you very much. All right. Thank you. We now have the pleasure of listening to Jane Kirtley, the Siller Professor of Media and Ethics and Law from the University of Minnesota. She was formerly the Executive Director of the Reporters Committee on Freedom of the Press. Jane.
Thank you, Oliver and Justice Breyer and honored guests and delegates. I've been fascinated to listen to this love fest that we have been indulging in this morning of the warm bonds between the press and the judiciary. Long may it last. I have not seen as much evidence of it as some of my colleagues apparently have. If we look at today's headlines, we see, for example, that in Camden, New Jersey yesterday, a state judge by the name of Theodore Davis imposed a $1,000 fine and community service on 4 reporters for the Philadelphia Inquirer for having violated an order that had prohibited them from speaking to jurors or trying to write about conversations with jurors who had served in a trial, a notorious trial involving the murder, a murder that occurred in New Jersey, and ended in a mistrial. He made the comment, "You're no different than Joe Schmo out there on the corner. You can't hold yourself above anybody else. The President of the United States has to obey court orders." And he went on to talk about the arrogance of the press and said, where do we go from here if the media has the right to basically say to a branch of government, we don't care about your order, we're going to do it our way. And in reading that this morning, I was reminded of some years ago in a case involving CNN, and you may recall the incarceration of General Manuel Noriega in Florida. CNN became privy to a tape recording that had been made of conversations between Mr. Noriega and his lawyers. In their interest in informing the public about the fact that certain employees of the federal prison system had violated the law by recording these conversations, they decided to air them. This caused a great deal of consternation on the part of the lawyers for General Noriega and ultimately for the trial judge who was presiding in the case. He issued an order that CNN should not proceed to air these tapes. There was some confusion about whether they actually violated the order or not, at least in CNN's mind. But some months later, the judge found them in contempt of court, even though he had ruled that the airing of the tapes had not undermined the ability of General Noriega to get a fair trial. I happened to meet this judge sometime after this ruling, and I said to him, Judge, tell me, please, why it was that you felt that you had to find CNN in contempt of court, even when you yourself had concluded that the airing of the tapes had done no harm. And I thought his response was telling. He said, I just couldn't let them defy me. With all due respect, I think this is the tension that ultimately exists between journalists and judges. It is in the nature of journalists to defy the systems of government in any free society. It is in the interests of journalists to test the system at every juncture. And this is sometimes seen by judges who, by their nature of their work, tend to want to control their environment, their courtroom, as being arrogant, as being disrespectful, and perhaps as even undermining the system of justice itself. And so it is ironic, I think, that as Justice Breyer reminded us, because the First Amendment is not self-executing, it is these very journalists who are constantly driving judges crazy, who then throw themselves upon the court when it comes time for them to assert the rights that are guaranteed under the First Amendment. And it takes a strong person, a person of great character and great courage, what perhaps Abraham Lincoln would have referred to as calling upon the better angels of our natures, for a judge who has been defied by journalists, who's been irritated by journalists, who even perhaps as the judge in Argentina a couple of months ago who issued the decision about the fact that Argentina apparently has a law that does not make hacking into computers and defacing web pages a crime. Judges like that to then stand up and say, but I will uphold the principles because they are more important than the particular skirmish or discomfort that I may have as a result of what the press is doing. I turn to another issue, journalism ethics. Gary Henksler made some reference to ethics yesterday. I teach ethics now in the position that I hold at the University of Minnesota. I have to remind any audience I speak to, and probably particularly this one, that journalism ethics is not an oxymoron. Journalists actually do believe in ethical principles, and one of the most compelling ones for any journalist that I know is to honor the confidentiality of a promise made to a source, to keep that source's identity secret. This is something that often becomes a major issue in the courts of this nation, and I suspect in your courts too, when we look at the reports that are made by organizations like the Committee to Protect Journalists every year to see which countries are jailing journalists. There's usually only maybe one that's gone to jail in the United States, but almost invariably that's been because the journalist has refused to compromise a promise made to a source. If that's not ethics, I don't know what is. And although I recognize that for many judges it is seen as someone holding themselves above the system, arguing that they should have special rights and privileges that don't belong to others. As the state Supreme Court of the state in which I now reside said, every citizen has an obligation to appear and testify when subpoenaed, and it is absurd that an entire class of citizens, the news media, would be exempt from such a civic duty. But I think this misconceives the role of the press in a free society, as we've been talking about today. I think the responsibility to build a case rests, in the case of a federal prosecution or a state prosecution, with the government. In the case of private prosecutions or private actions, with the litigants themselves, not with the press. The perennial argument that journalists have a duty to provide evidence just as any other citizen would rings very hollow in this situation. Of course, it would be much more expedient to compel journalists to comply with subpoenas, but the cost to freedom of the press and to the public's right to know would be profound. Journalists, in my view, do play a special role in society. They are not just any Joe Schmo. For them, good citizenship requires them to remain independent. We've been talking about an independent judiciary. An independent press is equally essential to democracy. And in my opinion, there can be no more compelling interest than that. Thank you.
Thank you, Jane. We now have the Honorable Gilbert Merritt from the U.S. Court of Appeals of the Sixth Circuit in Nashville, Tennessee.
Justice Breyer, distinguished judges and journalists and fellow delegates. I was glad to hear Justice Breyer talk about how difficult drawing the lines are in the cases that the court has before it, especially this term and last term. This term, well, first let me say that most of the cases that Justice Breyer and his court have to decide come from the courts of appeal, the court that I sit on, the court that Justice Breyer used to sit on. And I'm happy that he has described to you the difficulty of the cases, because in this most recent term, the court has reversed the positions that I took in about 3 cases, which is par for the course, par for the term, normal term of the Supreme Court. The cases are difficult, and occasionally I am able, most of the cases in which the Supreme Court reverses the Court of Appeals are by a divided court, 5-4, 6-3, and occasionally lower court judges like myself get an opportunity to unify the Supreme Court. Okay, and so this term I got a chance to unify the court. I was reversed 9-0. As you were told, I'm from Nashville, Tennessee. Nashville, Tennessee is the home of Andrew Jackson, the president whom Justice Breyer referred to as having said in the Cherokee Indian case in the 1830s, Mr. Marshall has made his decision, now let him enforce it. And of course, it was not enforced. President Jackson declined to enforce the order of the Supreme Court in the 1830s. I must say to you that Andrew Jackson is one of my remote forebears. He also was from Nashville, Tennessee, and we're proud of Andrew Jackson, but I must agree with Justice Breyer that he was wrong in that instance. And to illustrate the great difference in the power of the and importance of the Supreme Court, another Tennessean, Albert Gore, had a case recently in the Supreme Court of the United States, a case called Bush v. Gore, and he lost. And although he had the majority of votes in the election, the country quickly sustained the Supreme Court. There was no coup d'etat, and business went on as usual. We have come a long distance, and I want to discuss quickly in a little bit more detail one of the events that Justice Breyer referred to, the event of the impeachment of Justice Chase in the very early days of 1803 or so. I want to tell you this little story about that. In the 1790s, after the adoption of our Constitution and our Bill of Rights, the press and the federal judiciary were very weak institutions indeed, struggling institutions, and they were in serious conflict one with the other because of press criticism of the government and press criticism of particular governmental officials. Congress adopted in the late 1790s the Alien and Sedition laws to punish criminal offenses, as criminal offenses, the publication of seditious libel, primarily against public officials. The Federalist Party then in the United States, led by President John Adams and Alexander Hamilton, in general, supported the Alien and Sedition laws, and the followers of Thomas Jefferson and James Madison, the Jefferson Republicans, opposed those laws as violations of free speech. Some Federalist judges began enforcing those laws with a vengeance against pamphleteers, the press, and outspoken individuals. And when the Jeffersonians won the election of 1800, in part by campaigning against the Alien and Sedition laws, impeachment proceedings were brought against the most notorious of the Federalist judges, Justice Chase, a member of the Supreme Court of the United States, to impeach him, and he was almost impeached in the Senate. A bill of impeachment was returned in the House of Representatives. It almost was adopted by 2/3 of the Senate, as is required in our Constitution. There are many lessons we have learned from that impeachment. Many precedents were established in that impeachment. But for our purposes here this morning, the one I want to mention to you is simply that as a result of that and years of development subsequently, there is a kind of unspoken, silent, perhaps unconscious reciprocity that has grown up between the press and the federal courts, particularly the federal courts. There are lots of disagreements, lots of problems, as Jane Kirtley mentioned, but there is a kind of unspoken reciprocity, and it grows out of the fact that the press needs the federal courts in order to enforce freedom of speech and freedom of the press under the First Amendment. It falls, we, the judges, are not the only ones who enforce free speech. In the end, the public by accepting free speech, enforces it. But the courts are the institution now much stronger than they were in the days of Justice Chase and the Alien and Sedition laws. The courts are the institution in our society which daily on the front line enforce freedom of speech and provide a safety net for the press. The reciprocity for the judiciary comes in this way, that we, the federal judiciary, as Justice Breyer mentioned, we are not a democratic institution in the sense that we are elected. We are appointed for life on good behavior. And that is a counter-majoritarian institution, as we say here, and it must be sustained. And what we find is that it is the press which, for the most part, supports the independence of the judiciary, which educates the public as to the importance of the independence of the judiciary. And so there is this unspoken reciprocity between the two institutions, which I would commend for all countries and in all times. Thank you.
Thank you. We're now open to questions, and I'd invite questions from the floor to this very able panel. And in asking your question, if you could mentally separate questions from lengthy statements, it would be most helpful. And I don't know who you'd like to direct your questions to. Yes, Aldo. Is that mic working here? Yes? If you want to ask questions, if you wouldn't mind us coming up to the mic and lining up, it would probably save some time.
From Asunción, Paraguay, from Diario ABC. I have a question that I would like to ask Dr. Breyer and Dr. How do you pronounce? Góngora? Do you have an accent in your name? Góngora. Yeah, Góngora. What's happening, Dr. Góngora, is that there is a big difference between a judge and a journalist. The judge is being paid by the government. The journalist is being paid by his private institution. If the judge does something wrong, he continues getting his salary. But if the journalist is discredited, then the journalist is in the streets. And I think that is the biggest difference. Now, talking about criticisms of journalists.
I'm sorry, Aldo, could you move to your question?
Aldo, ¿cuál es su pregunta? In the time of dictatorships, justice was militarized. In the time of democracies, justice is politicized. So my question for Dr. Breyer is the following. How far can the judges accept or tolerate criticism coming from journalists without taking steps against them?
Well, Justice Breyer is answering that. If anybody else would like to ask questions, please come up to the microphone now. Justice.
I imagine you can think of the worst thing to say you could possibly say, and I'm sure there are many people who've said it about me in print. As far as I'm concerned, there is no limit as to what people can criticize judges for. Let them criticize. We don't take action against journalists, nor should we. That doesn't mean the journalist is right. Very often they're wrong. And if you say, is it irritating? Obviously. Obviously, I think I'm just wonderful. But the fact that others don't is up to them. But so I think that the basic rule in the United States is you can say what you want about the judge. And indeed, after all, in every case, there are two parties. The party that wins, the lawyer thinks he's a good lawyer. The party that loses, he thinks the judge is an imbecile. So it's not fair to judges to begin with, and if they don't like that kind of world, they better take up another profession. But that is the world we live in.
Thank you. Eduardo Olivari, and then Ed Seaton.
Sí, buenos días, Eduardo Olivari.
Yeah, I'm Eduardo Olivari, Director of La Nación of Costa Rica. I have a question here for Dr. Góngora. And we have spoken about the relationships between press and the judicial power, relations that can be harmonious or not. I think something that has to be considered is the relation of both with the principle of freedom of expression. And journalists and the press, because of the work, are defending the freedom of expression because it is their profession. In the judicial power, this is limited because they cannot express themselves so much that will risk the judge's independence or maybe give up some information on the cases they're working on. So, as you can see, there's a different use of the freedom of expression by both groups. The journalist goes all the way, and the judges don't go all the way. So how can this affect the resolutions that the judges are taking when we are judging the freedom of expression in other individuals?
Thank you. It's a very interesting and deep question. And I believe you are correct. The press must have freedom of expression or unrestricted freedom of expression in relation to judges. And the judge who cannot appreciate a criticism perhaps should do something else or devote his time to something else. As an author says that behind unjust criticism there is always a praise. Perhaps in some cases that could be right, but in other cases it would be right for the judge to take note of the criticisms made by the press or by newspapers, by lawyers, journals, like in the case of the Mexican Bar Association has a journal called Forum, where criticisms are made by decisions handed down by the judiciary, and we take very careful note of all of those criticisms made in those journals. Also, in the journals published by the different law schools of the different universities, professors criticize openly the sentences and decisions made by judges. So all of this really leads me to believe in something that I've mentioned many times, which is that once I came out of the law school, having passed my exams, that's not the end of the process. The lawyer, whether he is going to become a judge, is going to be scrutinized, he's going to be examined by his peers or by the authorities who could really annul and cancel his decisions, because this is something that should be considered and seen by the judge in a lower rank, that the opinions of those in higher ranks is more valid than his. Also, the Chief Justices of the Supreme Court, against whose decisions?
Of course.
Yes, against whose decisions there is no legal resource on earth, or nothing that really can go against them. They're also subject to criticism by journalists, by attorney. Even, in fact, many books have been written and very interesting cases, such as against Bush and against others.
Yes, hello, good morning. My name is Maribel González with Reforma, Mexican newspaper. This is a question for Dr. Góngora. Buenos días, doctor. Mi pregunta tiene...
Good morning, Doctor. My question has to do with the recently approved Transpiration and Communication Law in Mexico. I'd like to say the law prescribes a deadline for you to draw up the regulations. I would like to know what is being done to that respect, because at least openly and publicly this is not known. I would also like to know that once this goes into effect, are you thinking of opening up the judicial files of the case? Thank you very much. Thank you very much for your question. This is a question that I was very certain you were going to ask. A very prominent group of Mexican journalists created a task force or task group, working group, and promoted this communication bill. The judiciary has 1 year to prepare that regulation, which is going to be implemented through general rules. The law in fact, just went into effect. Now we already have a working group which is in charge of studying how we can and how we are going to implement those general rules and regulations to comply with what is provided by the law in this area, because of many of the problems that have been presented to us because of the law. For instance, that all the public opinions of the federal judiciary branch should be published, and there are more than 500,000 legal opinions that we have to publish. How are we going to solve this? We need a little more time to see how we're going to publish more than 500,000 legal opinions. I can assure you that we're going to be doing this in due time. Thank you very much. Good morning. My name is Elizabeth Vargas of the Legal Center of Colombia. My question is addressed to Judge Breyer. In Colombia, both in applying justice and the exercise of journalism is very risky. How has this crisis affected you so that one of the judges or journalists can go ahead and perform their duties and their objectives? That's one question. The second question is, to what extent can journalists, through the investigations that we conduct, are making a contribution to justice? How is this perceived by judge? How do you all perceive the investigations that journalists can really shed some light into the justice? Thank you.
I know that you have terrible security problems in Colombia, and I think all of us admire the judges who have been serving there under the most difficult circumstances. There are many people in your country in government offices and journalists as well who are very brave. We're very lucky that we do not have that situation here. And after September 11th, there has been additional security, but it's nowhere near the kind of problem that faces you. And so far, I don't believe that it has in any respect interfered with the work of journalists. when responsible journalistic work is done uncovering an injustice that then ends up in the courts, I think that's very helpful, and I think most judges think that it's helpful, and I can think of instances where it led to the correction of serious injustice. I think the greatest problem for the journalists and for the courts is what I'd call the less responsible on the journalistic side, which usually flows from ignorance, not from maliciousness. So what we found is the most helpful thing, and I'm only sorry when I read that journalists in the United States are working for newspapers and others who feel they should be fewer in number. I personally think they should be more in number. And the reason that I think that is when there are more journalists in number, they will tend to specialize. And courts benefit enormously when the journalists who are covering their activities are specialized in legal affairs. If you want to see the difference between the articles about the Supreme Court of the United States written by the handful of professional reporters who spend their career in the press room in our building, and those who occasionally cover a Supreme Court case, you will see the difference between night and day, or if I don't want to overstate, but I will a little, perhaps the difference between fact and fiction. We do not curry favor with the journalists who work for us. We do not give them special interviews. They have no we'll see any journalists occasionally and talk to them about what we do in general terms, but we do not give them any inside information about cases. They do their own work in the basement, reading the briefs, listening to the argument, and then writing about the professionally, the opinions that come out. And I mention that because I think much of the misunderstanding is where judges look at the work of the less knowledgeable journalists rather than the more knowledgeable. And I mention our work because I think it's helpful to have that professionalized group of people right there in the basement.
All right. If you'd like to ask questions, I invite you to come up and just stand by the microphone. And I know judges are generally more used to giving judgments, but should any of you wish to ask questions, I'd certainly give you some preference. Yes, ma'am, yourself, and then this gentleman. Go ahead.
Thank you. My question is actually quite related to the relationship between the courts, the media, and the public, and it's directed to Justice Breyer. My name is Monica Uriart, and I'm with Studies in Latin American Constitutional Histories. We're a non-governmental organization. And my question is this. You were just mentioning specialized journalists who are able to describe very clearly results of judicial decisions and what is in them. And my question is, if you could imagine press everywhere that was that skilled and a public that was equally conversant in constitutional issues and educated in them and were able to understand the difficult decisions of, say, the Supreme Court, do you think that the court would be less sheltered from a politicized view of its work, or do you think that democracy in the court's work would be strengthened as a result of a public who could understand the workings of the court very well?
What I believe is the more understanding, the better. And I'm curious what other people think, because I don't want to. You agree with that? So.
Thank you. The justice from Argentina. You, sir. You're on next. I'm going to give a little preference to anybody that has a red badge, because I might face some at some future time. Go ahead.
Adolfo Vázquez.
My name is Adolfo Vázquez of the Supreme Court of Argentina. I have a question for the journalist. Diane, usually journalists ask questions of judges, but this is the other one around. I have a question to the journalist. How do you see, as a journalist, or how do you assess the situation whenever there is a power struggle, as in the case between the judiciary or the legislative branch of the government or another branch of the government? And in that case, journalists, by following a certain trend in accordance to the prevailing political party, will go against the judicial branch of the government because it's another part of the government or another, which is not really respecting either the independence of the judicial power and is not respecting its own independence as a journalist.
My experience has been that journalists are generally contrarians by nature, and my own view is that to suggest that the press invariably would go against the judiciary and these kinds of slugfests has not been my experience. Journalists are skeptical by nature and inclined to engage in deflating any institution that they think has become self-important or overweening in the exercise of its authority. And certainly neither the executive nor the legislative branches are exempt from that any more than, if I may say so, the judiciary occasionally would be. I think, as Judge Merritt reminded us, journalists should be, if they are not in fact, acutely aware that when the drafters of the Constitution drafted the First Amendment, they were very much aware that a lot of the threat to a free press would come from the legislative branch. It is Congress that is prohibited from making any laws that would abridge press freedom here in the United States. Journalists, in my view, have much to fear from legislators, even those who might, in really good faith, attempt to pass laws to provide them with special privileges, because inevitably, if you have a special privilege, that means the government gets to decide whether you're entitled to invoke it. This is an issue that has come up here in the United States with the whole issue of who is a journalist, who is entitled to privileges, and so forth. So I can only tell you that I think that journalists should be, at least in any event, aware that the courts are ultimately going to be their saviors and protectors, recognizing, though, that part of the role of a journalist is to call all of the institutions of government into account. But in my view, it's not a question of favoring one over the other. It may perhaps be what Justice Breyer was alluding to, that in many respects, the judicial system remains the most impenetrable of the three branches and the hardest for a layperson to understand.
This question, I guess, is for Justice Breyer. In this day and a half of discussions, one of our primary targets to talk about is the elimination of criminal libel that exists in most Latin American legislations and even in some Caribbean countries. And it's a worldwide platform of discussion around the world. I wanted to hear possibly your opinion as far as the possibility of incarcerating a journalist for criticizing through a qualified criminal libel law, which also exists in about 17 countries in the hemisphere, called the insult laws. And I think that is of interest to everybody to listen possibly to your opinion. Thank you.
Well, what you want me to say is they're all bad, but the fact is I don't know the laws in the other countries. I know that here people are not put in prison or for criticizing a judge, and that's true whether they're journalists or not journalists. So I think we would find we have a pretty strong First Amendment, and the reason even that you get into cases of juror interviews and so forth is there is a due process clause that also protects the rights of the person at the trial, and the rights of an individual at a criminal trial are themselves very important, and sometimes there can be a tension between that and the First Amendment's protection of free speech to report on what goes on. That's why not everything in court is open. Sometimes you have trade secrets. Sometimes you have confidentiality that's necessary for security reasons, very rare, but there are ways of working these things out. I'm just saying sometimes there's tension and you have to have some kind of resolution of the competing rights. But among those things is not the question of whether to put a journalist or anybody else in jail for criticizing a judge. We just don't do it. As far, I mean, maybe you could find an example, but I'm not aware of any.
Would any other members of the panel like to speak to that point or not?
I might just mention again that in the early days of the Republic, the alien and sedition laws, which I mentioned, provided for putting journalists in jail for seditious libel, and some of them were put in jail. But that to some extent was fought out in the very early days of the Republic, and those laws, that law is no longer on the books and fell into disuse. And there may be some, historically in our country, a few examples of that since the alien sedition laws, but that one incident pretty much ended the effort to put people in jail for seditious libel or criminal libel. And so the only remedy in the United States is civil in nature.
Thank you. Harold, could I ask you to come up here more?
Mr.
Yes,
Chairman, I want to
of course.
Give a comment on my house. Excuse my English. En la misma forma en
Yes, likewise, as Justice Breyer was saying, I would like to praise journalists who specialize in the legal matters here in the United States, especially in court matters. Whenever I come to the United States, I buy a book about this sort of subject, and I recall one book that I was very much interested in about a journalist who specialized in the Supreme Court in the United States, who has this very bizarre title, 9 Scorpions in a Bottle. And nobody has been outraged about this type of book. For instance, in Mexico, we would talk about 11 scorpions in a bottle, but yet, as of now, no book about this has been written in Mexico, especially with a title this bizarre or sophisticated kind of book. Anyhow, I would also like to praise the judges and U.S. congressmen. For instance, in Guanajuato, during a meeting that we had that was attended by Chief Justice Rehnquist and Justice Breyer, Justice Breyer said during that meeting something that he repeated today. I believe, as he said, I believe that as justices, we should not have press conferences with journalists and give out information to journalists. I recall him saying that. And then a federal judge from San Francisco and then a federal judge from, I don't recall exactly what city in Texas, said, but we do hold press conferences for the media, and we do give out to the press information, and we also explained our sentences, our decisions to them. That's independence, that's liberty, freedom. That's what I tell the Mexican judges and chief justices, and that I congratulate you for that.
Pretty much out of time. We're going to have one more question, providing it's quick. Please, go ahead.
Gracias.
Thank you very much. The question is for Judge Merritt. My name is Javier Casas of the Press Institute of Lima, Peru. Judge Merritt, I have been listening to the different opinions expressed on the relation between press and the judges, and I believe that the analysis shows that the information that pertains to the judges and that which is published in the press really comes outside of the judiciary. And then again, some of the judges have also made statements that judges have to put up and tolerate criticism. But what happens if criticism against a judge? Yeah, my question is, what happens if the criticism against a judge comes from a judge in a lower rank or lower level through the media, through a newspaper? What happens if there is a problem among judges, which is something that begins to take place and be resolved at the level of the newspaper? Do you believe you have sufficient authority, or you have the right to criticize, openly criticize through the media, judge, a Chief Justice of the Supreme Court, for instance?
That if precedent in history is an example, there have been many instances of judges on other courts criticizing members of the Supreme Court of the United States or the states. It's not a frequent thing, and most judges are, all judges, I feel sure, in the United States, or almost all judges, are very reticent to criticize other judges, either on their own court or on a higher court. But it does happen, and when a judge feels that the safety or the security of the nation or some major question has arisen, and the Supreme Court of the United States or some other court is in error, they may criticize, and as far as I know, there's no law against it. It's a matter of judgment.
Justice Breyer, what do you feel like when you're criticized by a judge, sir?
It's normal. They don't, I mean, look, we're in a profession. Hey, is there some rule against criticizing a higher judge? No. If a person does it, is he punished? No. Do they do it so often? Well, I think most judges think maybe it's a fairly tough job, and even if we disagree with this other judge, maybe he has a point. So it's not too normal, but I can think of instances where judges wrote articles in the newspaper saying the Supreme Court is absolutely out of its mind. I mean, that's happened, and nothing happens. I tend not to agree with that, but nonetheless.
I'd like to thank the panel. You've had an exceptionally talented panel who has actually all spoken within their time limit, which is even more incredible. And we've dealt with a large number of questions. I'd like to thank you very much for your cooperation and hand it back to my boss, Alejandro.